Fellow law teachers, ladies and gentlemen, I deem it a privilege and honor to have been invited by Major General Neelendra Kumar, Director, Lex Concilium Foundation, for providing me this opportunity to share some thoughts as to how to teach labor laws to the undergraduate students. My starting point is to deal with the relevance of labor law. Here, I wish to mention that since labor law seeks to regulate relations between employers and workers, the reach of labor law is wider than any other law as it touches the lives of far more people as compared to any other branch of law. It is this aspect which makes it more fascinating of all branches of law, and therefore the study of this subject is of enormous and ever changing dimensions. Coming to the question as to how to maintain high standard to achieve the goal of excellence in the area of labor law, in the law school, or even in business school. In my opinion, in order to achieve the goals of excellence, the principal tasks are in three areas. Firstly, the teaching staff must be developed and maintained at a high standard in view of the competition, both at national and international levels. The same is equally applicable to labor law teachers. Secondly, it is necessary to attract talented and best students. Thirdly, the while broadening the legal education in general and labor law in particular, training and research in labor laws must be intensified. Having said so, we turn to discuss briefly the development of labor laws in India. Over the years, labor laws have undergone a change both in regard to their objects and scope. Early labor legislation were enacted to safeguard the interests of employers. They were governed by the doctrine of laissez-faire. Modern labor legislation, on the other hand, aims to protect the workers against exploitation by employers. The advent of the doctrine of welfare state is based on the notion of progressive social philosophy, which has rendered the old doctrine of laissez-faire obsolete. There has been remarkable change in the approach of labor laws and industrial relations since World War II. The law, as developed after the Second World War, particularly in welfare state, has reversed the theory of Sir Henry Maine that the movement of the progressive society has hitherto been the movement from status to contract. And now the society has progressed from contract to status. The Philadelphia Charter, adopted in 1944, provided that labor is not a commodity and that poverty anywhere is a danger to prosperity elsewhere. W. Friedman and other jurists who attempted to analyze the essential characteristics of the legal development in this area have tried to look into from a different point of view. Labor laws, which inter alia seeks to regulate relations between the employer and workman, as mentioned earlier, doesn't address several problems. Further, there are multiplicity of labor legislation, multiple definition of the same or similar term, disparate jurisdiction, different instrumentalities, and multitude of practices, which also led to conflicting decisions, giving rise to confusion and chaos. Even though labor laws have been amended, During the last 5 years, it cannot be denied that they have become obsolete. Indeed, they suffer from various defects and shortcomings. Thus, most labor legislation are not applicable to unorganized labor, which constitute about 92% of labor force. Further, most labor legislation is more than 7 decades old. There is a feeling that our labor laws are overprotective, overreactive, fragmented, outdated, and irrelevant, and as such creates hurdles in achieving the objectives of fair labor practice. The emergence of globalization, liberalization, and privatization has brought new challenges that is, therefore, a mounting pressure to reforms labor laws. The first National Commission on Labor, which reviewed the entire gamut of labor laws, emphasized the need to bring labor reforms and made a series of recommendations. The second National Commission on Labor, which was set up by the Government of India in 1999, in its report submitted in 2002, inter alia recommended that 44 central legislation at that time be categorized into 4 or 5 groups, such as law relating to industrial relations, social security, and occupational health, safety, and working conditions. However, the report was getting dust for more than 12 years. It was during 19, not 19, but it is 2015 that the Ministry of Labour, Government of India, took initiative to codify central labour laws into 4 labour codes, namely the Industrial Relations Code, Code on Wages, Code on Social Security, and Occupational Safety, Health and Working Conditions Code. The Code on Wages Bill was passed by the Parliament on 2nd of August 2019 and received the assent of the President on 8th August 2019. The other 3 bills, namely the Industrial Relations Code, the Code on Social Security, and the Occupational Safety, Health and Working Conditions Code, were referred to a standing committee of labor. After recommendations of the committee, the government replaced these bills with the new ones in September 2020, which were passed by the Parliament on September 23, 2020, and thereafter received the assent of President on September 28, 2020. However, the date of the commencement of the 4 codes and the rules framed thereunder has not yet been notified. These 4 labour codes subsume 29 central labour legislation. Quite apart from this, there are 7 other central legislation which deals with the labour besides the state labour legislation. We now come to the contribution of Indian judiciary. A survey of decided cases reveals that Supreme Court has played a significant role in formulation of industrial jurisprudence. It is not only made a distinct contribution to the law relating to industrial relations, social security, minimum standards of employment, but has innovated new methods and devised new strategies for providing access to justice to the weaker section of society. Indeed, court has acted as a protector of the workers and at times even played the role of legislators where labor legislation is silent or vague. In fact, many labor legislation and legislative amendments which have taken place were in response to the call by judiciary in protecting the interests of workers. The court has also enlarged the contours of fundamental rights to equality, traffic in human being, and right to life and personal liberty provided in the Constitution. Needless to add that by virtue of Article 141 of the Constitution, the law laid down by the Supreme Court is the law of the land and its decisions are binding on all courts. Coming to the application of labor laws, it may be pointed out that it is applicable to industrial establishment including factories, mines, ports, dock, transport, plantation, and shops and commercial establishments. It covers not only the employers and workers, but also covers the contract labor. Some of the labor legislation even covers workers in the unorganized sector, which constitute 92% of the labor force in India. We now come to deal with another issue, which is often asked by young law teachers who is assigned to teach labor laws as to how to create and retain the interest in labor law class. Experience shows that in order to create and retain the interest of the students in the class, it would be desirable to involve the students by raising the issues inform the story, wherever, of course, it is possible. Depending upon the case law, if any, or involve them in the discussion by raising issues relating to the topics for discussion. However, the approach may differ from teacher to teacher and from the topic also. For example, in order to deal with these issues, one may raise following issues and topic given uh, by me later. And here I would also like to mention that it is necessary to take or to emphasize on the issue, on raising questions, namely coming first to the, say, for example, when one may like to teach voluntary arbitration, he may wish to start his lecture by asking questions such as why the provision has been made under the Industrial Disputes Act for settlement of industrial disputes by voluntary arbitrator. Another question which may be raised is what are the problems involved in the system in India? Thirdly, he may wish to ask, is arbitration a component of collective bargaining? Whether resolution of disputes by arbitrator chosen by the parties create a win-win situation? And then lastly, among the other questions, one may wish to ask why voluntary arbitration is not successful in India. Let us now take another example of Interstate Migrant Workmen Act. While teaching this portion or this section, one may start by raising a question, namely, who is a interstate migrant workman? Whether labor law seeks to regulate their conditions of employment. What is the impact of COVID-19 upon the interstate migrant workmen. One may wish to refer to my paper on this aspect, and here I would like to mention that recently my paper on a crisis in legal protection of industrial, uh, uh, industrial migrant workers, published in the Journal of Indian Law Institute at page 195 onwards. This paper examines the crisis in providing legal protection and social security to interstate migrant workers. It identifies the shortcomings and lacuna in the existing provisions of labor legislation relating to interstate migrant workers. This paper also examines how failure on the part of the enforcement officer to enforce the relevant labor legislation led to crisis. Let us take another example of teaching the social security of unorganized workers. While discussing this topic, one may wish to ask a basic issue as to who is unorganized workers. What are the new forms of work done by unorganized labor? For instance, there are gig workers and platform workers. Then a question may be asked at what legal protection and social security has been provided to unorganized labor under labor laws. Further, one may wish to question, are these protections adequate? And if not, what need to be done and what should be the roadmap? Similarly, one always finds difficulty in creating interest while discussing the history of a trade union movement or even development of labor legislation. Here, I feel that it is better to divide it into different periods and then involve students in finding out factors which led to the change in each period. Then I wish to take another example, and that is of the contract labor. One may ask a question, what is contract labor? Why do we have this system? What are the protection which is afforded to the contract labor under the labor laws? What will happen to a contract labor on issuance of notification prohibiting the contract labor? Because here the question arises whether he would be the employee of the contractor or whether he will be the employee of the principal employer for which he is working. Having raised these issues, we turn to examine as to how the course on labor law be categorized. As discussed in my book on industrial relations of labor laws, which is published by the Vikas Publishing House, and the last edition was 7th edition, where I've tried to classify labor legislation into 5 broad categories, such as industrial relations legislation, social security and labor welfare legislation, minimum standards of employment legislation, then we have the wage legislation, and lastly, the prohibitive labor legislation. This brings me to the issue as to how to divide and demarcate the lecture. Broadly speaking, lectures on labor law may be divided into 5 sections, namely, Section 1 may contain industrial relations and labor laws, where besides introduction, you may like to discuss industrial relations and industrial relations code. You may wish to include constitutional framework and labor laws. Then you may like to incorporate industrial jurisprudence, trade unions of workers and employers organization. Then you may take up the trade unions and the law, followed by the collective bargaining. After having giving such a background, you may wish to take up Industrial Disputes Act, where you may discuss the definitions and concept. Then you may like to take up the settlement of industrial disputes. Then the powers of and functions of the appropriate government. Then you may wish to incorporate the instruments of economic coercion, namely strikes and lockouts. This should be followed by the management of discipline and notice of change. Then you may take up another act which is extremely important, and that is Industrial Employment Standing Orders Act, and also the workers' participation in management. The second section, which is devoted to social security, one may like to discuss the concept of social security, the classification of social security, and then we may take up the different acts which govern social security, namely the Employees Compensation Act, Employees State Insurance Act, Employees Provident Fund and Miscellaneous Provisions Act, Payment of Gratuity Act, the Maternity Benefit Act, and the Unorganized Workers Social Security Act, and lastly, the recent one, namely the Code on Social Security. The third part or section, whatever you call it, may contain wage concept, where you may wish to discuss the concept of living wage, fair wage, minimum wage, or even need-based minimum wage. Then you may like to include all the 4 basic labor legislation dealing with wages, namely the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, Equal Remuneration Act, and the Code on Wages. With this, I come to the 4th section, which deals with the minimum standards of employment and working conditions. Here, it is necessary to include the Factories Act, the Plantation Labor Act 1951. One may even wish to include the Interstate Migrant Workmen Act 1976, and then Shops and Commercial Establishment Act, and then Occupational Safety, Health and Working Conditions Code. In the 5th section, which I may call it as prohibitive labor legislation. Three legislation may be included, namely the Contract Labor Regulation and Abolition Act, Child and Adolescent Labor Prohibition and Regulation Amendment Act 2016, and then you have the Bonded Labor Abolition Act. The next issue is what should be the method of teaching? I think here views may differ, but I feel that like Anglo-American laws, labor laws in India, it springs from a random mixture of statute and judicial decisions. In view of this, law teachers teaching labor laws generally prefer to teach labor laws in the light of relevant statutory provisions, judicial decisions, ILO conventions, if any, on the subject. He may wish to include recommendations of the committees and commission, keeping with in view the socio-economic perspective. Of course, method and style may differ from teacher to teacher. I personally feel that while teaching labor laws, emphasis should be laid on critical analysis of statutory provisions and judicial decisions. I have tried to maintain this approach in my writings, particularly in my book on industrial relations and labor laws, published by Vikas Publishing House, of which I have already mentioned earlier. Even I have tried to maintain similar approach in my another book, which I have revised for the Indian Law Institute, namely the Labor Law and Labor Relations, which was published in 2007. Coming to the prescribed and recommended reading, one may wish to recommend and even to prescribe the following course. I would prefer if you consider my book on industrial relations and labor law, published by Vikas Publishing House. The seventh edition was published in 2020, and you will find very recently, maybe in a couple of months, the eighth edition, which is in the press. The another book which you may wish to include in the prescribed reading is Labor Law and Labor Relations, Cases and Materials, published by the Indian Law Institute, New Delhi, in 2007. Among the recommended reading, I propose that you may wish to see a book written by myself and Colin Gonsalves on cases on Indian labor laws. Then it is necessary to make a reference of the two reports, namely the reports of the first and the second National Commission on Labour. It is also necessary to incorporate the ILO conventions and recommendations. And then in the recommended reading, one may wish to include all the four labor codes, namely the Industrial Relations Code, the Code on Wages, the Code on Social Security, and the Occupational Safety, Health and Working Conditions Code. Quite apart from this, I wish to mention that the Eastern Book Company, Lucknow, published one of my book on social security and labor laws, which is of course out of print. Then the Printers Hall of India Limited also published one of my book on labor law in factories, mines, plantation, transport, shops, etc. Quite apart from this, two other books are on child labor, which has been published in 2017 by the LexisNexis and Universal Law Publishing. And then we have a contract labor book, which has been published by the Book Line. And lastly, I have a book on legal protection and social security in unorganized sector, which has been published in 2017. These books may help you, and it's for you to determine which book will be most useful for your point of view.